Appeals Division 1 is now in session.
Please be seated. Good morning. As a preliminary matter, for those who feel comfortable doing so, please do feel free to remove your mask for the purposes of argument. Now, we are here for oral argument in CV20-0129, Nicdon 10663 versus Desert Mountain Master Association. As you may know, we record and live stream these proceedings, so please give your name and the name of your client when you begin your remarks. According to current protocol, as you're aware, you will be arguing from your council table. You may do that standing or sitting, whatever is most comfortable to you. The microphone is what is recording, and I understand there are some folks who were going to be watching the live stream from elsewhere in this country, so let's make sure that we get the microphones for their purposes. You do still have to keep track of your time, and you each have 20 minutes maximum. You're not required to use all that time, although you're free to. The time clocks will run on the podium. You're free to do what you need to do to look at that. We'll try to give you some signals, or you can informally keep your own time, whatever works best for you. But feel free to ask at any point. Now, please keep in mind, we have read the briefing, we have reviewed the record, we discussed this case in conference this morning, and with that, please feel free to proceed.
May it please the court, my name is Jonathan DeSalles, and I represent the plaintiff and appellant in this matter, Nicdon LLC. Property ownership rights are among the most important rights we have, and this includes inherently the right to rent. Now, there's a misconception that if you buy into a homeowners association, you sign away all of your rights. However, the law recognizes that some restrictions are invalid and cannot be enforced no matter how many people or your neighbors might be in favor of that restriction. We are here today on a rental restriction amendment. And there are two main reasons why this amendment should be declared invalid. First, it is inherently unfair and unreasonable, both because it imposes substantial and unforeseeable new restrictions on owners who did not consent to them, and secondly, it is arbitrary, illogical, and serves no legitimate purpose.
Counsel, also, at the time that of the property purchase, didn't the city of Scottsdale have an ordinance with this exact same, or at least a very similar restriction?
The city of Scottsdale had a similar ordinance. The test of foreseeability, however, is an objective test. The parties agree to that. When you force the parties to look at events and situations outside of the four corners of the document, what you have is a patchwork quilt of foreseeability, where someone who purchases on a Tuesday when the statute's in force, it's foreseeable for that person. But a person who purchases on a Friday when it's not in force, it's not foreseeable for that person. And what results is what this court has previously said in the Riley versus Boyle case is you can't have a patchwork quilt of different restrictions for different people. And that's what would happen here if you force a homeowner to look outside the four corners. In addition, the Wilson case...
Homeowners are typically subject to municipal ordinances, right? We're not saying that living in an HOA exempts you from whatever municipal ordinances are in place.
Absolutely not. But the issue in this case is that the ordinance was no longer existed at the time that this amendment existed. So this is not a situation where the homeowners...
What existed at the time they purchased the property? Isn't that the...
It did.
It did exist?
It was in force, yes.
So what reasonable expectation would they have that it wouldn't be enforced, or that they could operate their property in contravention of a express ordinance and CC&Rs that also incorporate by reference all laws?
Well, again, the test is an objective test, and you can't expect someone to. First of all, this ordinance was not enforced. There's nothing in the record suggesting it was enforced. In fact, what's in the record is that the short-term rentals in this association were frequent. There are several sub-associations here, and there are 6 villages that had short-term restrictions. This one did not. So the question is, and as this court...
Let me ask you a question now.
Yes.
Because when they bought, it was in law that they couldn't have the short-term rentals. That's what Scottsdale, the municipal ordinance said. And the HOA, the declarations say, if the HOA is modifying this just to conform to law, it can be done with the vote of the board of directors. So when they bought, this could have even been done just with the vote of the board of directors. How could that not be foreseeable?
Because at the time of the amendment, there was no ordinance in effect.
Right, but we're talking about foreseeability. So when they bought, there was a law in place that the board could have adopted an amendment to the CCNRs to conform to that with just a simple vote. They didn't even have to put it out. It wasn't subject to the major decision requirement.
And I disagree. Anytime you impose a new restriction, you can't artfully get around that with a generic amendment provision that would, in that case, allow just simply a board of directors to impose a restriction that previously did not exist. This court recognized this back in the Wilson case, where it said if a recorded declaration does not contain or at least provide for later adoption of a particular restriction, not a generic restriction, but a particular restriction, then that future restriction is invalid. In Dreamland, this court recognized this, and this court has recently, in the Braden case, Sunburst Farms versus Braden, and the Nickerson case, recognized that Dreamland stands for the proposition that if you inject new restrictions on homeowners, you are fundamentally altering the nature of the contract that exists between them
But it's
and
not
the
just
association.
any restriction, right?
It is not
Dreamland
just any
stands for pretty significant restriction, going from no HOA, no fees to mandatory fees.
Well,
That's different than what we have here, isn't it?
Well, I would submit to you that when you have a fundamental right of property ownership and you are imposing a restriction that limits how you deal with that right and how you get to treat your property, that is akin to that is a major impact similar to what you have in Dreamland.
But I mean, by their very nature, HOAs have a broad range of restrictions on your property right that you agree to, and I don't think you're here saying that any new restriction on your property, without bounds to that statement of any restriction, is invalid by definition.
We are not saying that any restriction is invalid. What we are saying is that it has to be a foreseeable restriction, and it also can't be a restriction that lacks a justification that's invalid or arbitrary.
Well, help us. Where's the law that governs what's arbitrary, what's unforeseeable? These are words easy to throw out there, but how does one decide what that means?
And that's why we need an objective test.
And what is that test?
The test is it from if you look at the 4 corners of the document, if there is something in the 4 corners of the document that makes it, that provides sufficient specificity that puts purchasers on notice, there has to be something that contemplates a later adoption of a particular restriction. Let me give you an example in this case. In this case, if we talk about there's an animal restriction in Exhibit E, it's section 1.1.4. That restriction says that you can have a reasonable number of animals. So it's foreseeable that because you're on notice of a reasonable number, the CCNRs may be amended to limit you to, say, 2 dogs. This is also the restriction. This is also the exact illustration that's in the restatement of property in section 610, illustration 12, concerning pets. Again, what we have here is more similar to Dreamland, because the ownership of property and the right to rent, to do with your property what you wish. We are dealing with an inherently unfair restriction that comes in later and says you can't.
Isn't it a little narrower, though? Because this isn't a restriction on all rentals. It's a restriction on what is a relatively new concept, which is turning your home into essentially a B&B or bed and breakfast or a hotel, which wasn't something that HOAs had to deal with before. And they're allowing, with this amendment, the same kind of rentals that historically had been in place. So I'm just kind of confused how this is such a fundamental right that it's a right to a short-term, basically one-night rental, if that's what you want to do.
Under this provision, it's a 30-day rental, and the
No, but you're asking for, you're saying that they can't have any restriction on rentals. I mean, basically, we would be striking this.
You would be striking the temporal restriction that's placed on rentals in this case, correct?
Would you
So-
say a 24-hour restriction would be unreasonable, and arbitrary if it was
I'm-
less than 24 hours?
I'm saying under the Dreamland case, it's inherently unfair because there's nothing to put the purchaser on particular notice that that restriction may be imposed. Going back to your question, however, the CC&Rs in section 1.8 specifically say leasing does not constitute a trade or business. There's nothing in section 1.8 or anywhere else in these CC&Rs that say leasing for more than 30 days or leasing than less than 30 days. Leasing is the right you have when you own property. And especially in the case, and it's
Doesn't that actually cut against you? Because now, and this is part of what I was wondering, that's a reference to leasing, just like a reference to pets. So you're on notice that the HOA may do something with leasing because it's mentioned.
No. The
Why
mere
not?
mention of a word does not put you on notice that there may be a restriction. References to leasing in these CC&Rs would include section 1.1.15, section 1.8, section 1.2.2 before the amendment. What these provisions do, they reinforce the right to rent unfettered with any restrictions. And what this is now the association comes in and they impose a restriction where none previously existed. Rather than put the person on notice that there might be a restriction, it puts the person on notice that there is no restriction.
I'd like to switch gears if
Yes.
I could, because the other part of this is really the language of the contract, the language of the declarations, and it's a contract. And it provides for, under 5.2, the supermajority vote of 2/3, but there's a qualifying clause to that sentence. If that sentence had ended right before it starts who are present, then I think we might not even be here. But it doesn't. So one, I'd like to know how do I read it the way you want me to read it? And if it's an ambiguous sentence, how do we resolve the ambiguity? So two questions.
First of all, you need to read it in the context of the entire document as a whole, and that includes section 1.33, which says when you have a fraction, it talks about a fraction of the whole. Now, the specific language that you reference is the language of the eligible votes in the association who are present in person or by absentee ballot. This is language that talks about a method for voting, identical to what's in ARS 33-1812. It's a distinction between proxy votes, for example, and voting. It's the exact language that's in 33-1812, and it tells you how you vote. And to answer your second question, how you deal with the issue of if this is ambiguous, well, you have to go back and look at the intent. And the intent in this case was clear. The intent in this case was to give one member, the golf club, favored nation status amongst everyone else. The literature that was circulated prior to
In
the vote.
interpreting a phrase in a contract, we're not looking at the intent as to this provision. We're looking at the intent of the.
Oh, I'm sorry, of section 5.20.
Yeah,
520.
why are you jumping off to go to outside sources, or are we still on the plain language?
Well, we're still on.
Because if we're still on the plain language, I'd like to jump in here. It's like there was a really simple way for the drafter to make this clear, and that would be to or more clear, if you will, and that would be to just simply use the definition, majority of members from 1.33. That's clearly defined. It means 50% of the total votes until to be title to be cast by members. Okay, and
No, if I may, I need to interrupt.
why couldn't they use that? Why wasn't that used? And the absence of that definition, what does that mean?
Well, you do need to use 1.3. You do need to use 1.33. And what 1.33 says is that any fraction referenced is a fraction of the total votes. So it's 2/3 of the total votes to be cast.
Let me read what 1.33 actually says. It says, any specified fraction or percentage of the members means that fraction or percentage of the total vote, a specified fraction or percentage of all the members except developer. So is that the language you're referring to, or you're saying
No.
the previous line? Any specified fraction or percentage of members with respect to a given matter? So,
Yes.
okay, but this same provision says later on, unless otherwise specified. So isn't 5.20 the otherwise specified?
No, because what 5.20 says, 5.20 uses a specified fraction of the members. And again, the additional
But it
language.
doesn't use the definition. The definition is majority of members.
Well-
Means, and that's nowhere to be found in 5.20. I mean, think about this as if they're statutes. Why would we pretend that one statute incorporated a definition that's nowhere to be found in the four corners of that section?
Well, and if I may, Your Honor, what you're focusing on is the majority of members, that the part that's underlined, and both in statutory construction and contract construction, we don't look at headings.
It's part of this sentence. Counsel,
It
it's
is-
part of this sentence.
But it goes on to talk about a specified fraction. Any specified fraction of the members means that fraction or percentage of the total votes entitled to be cast by members. It doesn't talk in that
But then
part.
but then it says, unless otherwise specified, the third sentence.
No, actually, but you're looking at the wrong, you're looking at the second sentence, does not say
The
unless
third sentence
otherwise.
says unless otherwise specified.
But that third sentence talks about all the members except for the developer.
The third sentence says, unless otherwise specified, any provision herein requiring the approval of members means approval by a majority of a quorum of members. What does that mean? Under the plain language of that sentence, what does it mean?
Under the plain language of that sentence, that sentence does not apply, because what we're talking about here is 2/3. We're talking about the sentence closer up. I'd like to reserve some time for rebuttal.
Sure.
I have 4 minutes left. I'd like to reserve that if I could.
May it please the court, Curtis Eckmark on behalf of Desert Mountain. Every single owner at Desert Mountain had a right to rely on the recorded declaration. Nowhere in that declaration does it promise that it will not be amended. To the contrary, the declaration specifically provides that the members can amend. It specifically provides that the board, through 5.2, can add additional use restrictions. And it specifically provides that the board has further rulemaking authority with respect to rentals. 1,323 people exercised those rights under the declaration, and it would be manifestly unjust if one single owner was able to void all of the owner's rights and instead unilaterally veto a vote of the membership, especially in light of the fact that the purpose...
But it isn't one board member. What we're talking about is whether or not it needs to be 2/3 of a quorum of members, or whether it needs to be 2/3 of the members. So it's not one person who would be defeating it. It's whether or not the HOA had the requisite number of votes to pass it.
That is the correct legal question, Your Honor, but it is one person challenging it. Everyone else has accepted the actual vote. There's only one person challenging it. But getting into that, that brings us up to the fact that 3 specific provisions of the declaration authorize this. The first is 4.2. 4.2 not only warns that there are use restrictions, it warns that they may be amended, and it specifically warns that there may be new use restrictions added through the process in 520. 520 is a hybrid process. It is somewhere between a board vote and a membership vote. because in some cases, there's no membership vote even required under 520. And when there is a membership vote required under 520, it requires 2/3 of those voting. There is a provision in the declaration that requires 2/3 of everyone, and that is 516. 516 is exactly what a provision in the declaration looks like when it requires 2/3 of everyone. 516 specifically states it requires the vote of 2/3 of all the members, period, end quote. 520 does not contain that language. 520 does not require 2/3 vote of all of the members. 520 requires 2/3 of the eligible votes, and this is the key language, who are present, and you can be present either in person or by absentee ballot, at a meeting specifically called for that purpose. So there is a crucial distinction between those two provisions. 516, along with 7.3.4, 10.3, and 19.1, all of them set forth a percentage of the members.
Council, why didn't the drafters, sure you didn't, I don't know if you know who drafted this, but whoever it was.
It was me.
Okay, all right. Well, there you go. Why didn't the drafters use the same language from 1.33 to clarify that it would be a majority of a quorum of the members?
Because the intent here was to create a hybrid provision where there was not even a quorum required under 520. What 520 says is you send it out to the membership. If less than 10% object, then it just becomes valid. But if more than 10% object, then we send it out for a meeting of the members. And at that meeting, then we count the people who are present and voting, and if 2/3 of those who are present and voting are in favor, then it passes.
Whether it's 100 or 1,000.
Exactly. And, by the way, with all due respect, that
I'm sorry,
issue's-
but isn't there something a little incongruent about that when what we're talking about are votes on something called major decisions, which would include things like selling off all the common property or going into debt on behalf of the...
Great question, Your Honor. First of all, major decisions refers to major decisions of the board. That's what 520 is. It's a process where, like I said, sometimes there's not even a vote of the membership required. So it doesn't make sense to rank these provisions, and even if they're separate and distinct, unique provisions. And even if you do rank them, this would be a less of a burden or less of a bar than something like 19.1, because 19.1 always requires a vote of the membership. And that was the whole point of this. This was supposed to be something that, hey, the board's going to do this. And if enough people object, then we'll put it out for a vote of the membership.
So let me ask you, so you're saying there isn't even a quorum requirement in 520. So the board sets the meeting for 3 o'clock in the morning on New Year's Day in some remote location, and 3 people show up and 2 of them vote for it, it's done. And with that, the board could have sold all of the community's common area, done a special assessment of $1 million on each home, all of these kinds of things.
With all kind of, Your Honor, with half of that. I do agree with you that there's no quorum requirement. Although I will say that in this case,
So 3 people is all you need.
correct. Although I will say in this case that's irrelevant because we did meet the quorum requirement. We had 1,700 people vote in this case, so we far eclipsed the 25% quorum requirement in the bylaws. But the point is, everyone has gotten notice. At least 240 people have already objected. And so the odds of only 3 people showing up at that point in time are virtually nothing, 0. And as of course in this case, that's exactly what happened. In this case, we had 1,700 people vote because that's what the process is designed to do. All the members have already gotten not 1, but 2 notices of this by the time we get to the vote. So there is no quorum requirement, but even if there were, we satisfied the quorum requirement in this case.
The
And
quorum
that's,
requirement, you're relating that to 1.33?
no, the quorum requirement is set forth in the bylaws as 25%.
1.33 says as defined in the bylaws.
Correct. And 1.33 cannot apply to this particular provision because 1.33 defines terms that are not used in this provision. This provision does not contain majority of the members. This provision does not contain a specified fraction, quote, of the members. That's what 1.33 defines, specified fraction of the members. This particular provision says a specified fraction of those voting and who are present at a meeting. And if you accept Nicdon's interpretation of applying 1.33 here, you would end up in exactly the opposite position of what the language says. Because when you read the language, it says that when we do the math, we only count the people who are present. And under Nicdon's interpretation, you would count the entire community. And that obviously is the opposite of just counting the people who are present. That's why that language present
Let's
is...
say we've said that it could be read that way, so it's ambiguous.
Okay.
I mean, there are two ways to read that sentence. I think there is that there. And that who are present is just simply an explanation that, as counsel said, you can't do proxy votes. You've got to actually have votes, either absentee ballots or in person. How do we decide which interpretation applies?
If it were ambiguous, then you would go to the intent of the drafter. And in this case, the testimony is uncontroverted that Mr. Borsch, who was one of the drafters, testified that the intent of this provision was to acquire 2/3 of those voting, not 2/3 of the entire membership. And that testimony is very powerful because Mr. Borsch actually voted against the amendment. And so, but he was honest enough to admit in his deposition that when he drafted this, when he was involved with me in writing this in 2011, his intent as the president of the board was that it would be 2/3 of just those voting.
In terms of the agreement, you pointed to 516 as one other place. I think you mentioned 1.9.
7.3.4, 10.3, 19.1.
Okay. And are there any other places in the document that we would look to try and resolve the ambiguity?
Yes, I think not if it meant 2/3 of those voting, it would have had the exact same language, or excuse me, it meant 2/3 of the membership, we would have used the exact same language we did in 516. To me, that's telling. It would have said the same thing if that's what we meant. The other thing is there's an important distinction both within the document itself. Earlier in 520, it says 10% of the members. But when we come to the vote, we don't say 2/3 of the members. We use completely different language. So that distinction is present not only within the document, but within the exact provision itself. Also, the Nebraska Supreme Court, in looking at virtually the identical language, has said it's improper to consider only a fragment of the provision and said the court has to give meaning to the rest of the provision that modifies the percentage. And
What
the
is
modifying
Nebraska
language is...
case? I'm sorry, I was looking for the Purple Cow case that looked at this language.
There is a case from Nebraska cited in our brief, Your Honor,
Okay.
in this section that dealt with the exact same language. And it says you can't just look at the percentage, you have to look at the language that modifies it and says a percentage of what. And in this case, it's a percentage of the people who are present. Now, Nicdon also, this amendment, because we got a majority of the members in this case, would be valid under 19.1, and the board had the authority to do a rule pursuant to 5.4 because 1.2.2 specifically says that the board's authority with respect to rules extends to leasing. So there's actually, this is valid under 3 paths, 520, 19.1, and 5.4. Nicdon seeks to replace the language of the declaration with a unanimous consent requirement. And the ramifications of that are severe because all but the tiniest of associations will be unable to amend their documents if unanimous consent is required. And that is the reason that the legislature on 4 separate occasions has specifically rejected that. The first was when the legislature enacted the Planned Community Act. They borrowed a ton of provisions from the Condo Act, but the one of them that they did not put in, that they refused to put in, was 33-12-27. And that provision requires unanimous consent for certain amendments in condominiums. The legislature rejected that. Then the legislature enacted 1806.01. And in that case, the legislature specifically said that owners like Nicdon have to use their property in accordance with rental time restrictions in declarations and amendments. And the most important thing that the legislature did was enact ARS 33-18-17. because that statute specifically tells us how a planned community can amend. And what
Council,
yeah.
if we could, you're down to about 8 minutes, and I'd like to talk about the foreseeability and reasonableness
Yeah.
arguments that were made. One of the issues raised is, we know what the board's justification was, the safety, security, that justification. Appellants suggest that that there were nefarious ulterior motives to this. What, if anything, allows us to look beyond the board's asserted justification? Are we obligated to look into whether that's the actual justification?
With all due respect, Your Honor, you're precluded from doing so because of 1817. Because 1817, the legislature said there's only one test for evaluating amendments, and that test is whether they met the provisions of the declaration. That is it. And the legislature specifically created an exception. Nicdon wants to create an exception saying, whoa, if it's not foreseeable, you can add this other test. And if it's not, if it's significant, you can add this other test. But the legislature has told us in 1817 that you cannot do that. And we know that the legislature considered whether to create exceptions because they created one, and only one. The legislature said that the only time that an association needs to get individual consent from an owner is when the amendment applies to less than all of the units. And so the legislature has spoken on that position. In 1817, it's told us that the only test is whether you complied with the CC&Rs. So anything else, applying dreamland, foreseeability, all of those other things would be in violation of the statute. But even if we do go there, the plaintiff can't meet either one of the prongs that they failed in dreamland. In dreamland, the plaintiff had a reasonable expectation of not being dragged into an association against their will. Here, in this case, the law cannot recognize a reasonable expectation to do something that's both illegal and in violation of the declaration at that time. In dreamland, there was no association. In our case, they have to show that there was if dreamland applies, which I don't think it does under 1817, but if dreamland applies, then they would have to show a substantial alteration of the nature of the covenants. And in this case, we had overwhelmingly residential covenants. We had CC&Rs that said residential use, no business use, no more than 2 unrelated people could use the property during any 365-day period. You had a specific provision in the CC&Rs that said every lease needs to say that you can kick the person out if they violate the terms of the governing documents. Well, that's not consistent with nightly or weekly or weekend type rentals. So these covenants were absolutely consistent. Also, in terms of foreseeability, Dreamland had just a generic 50% amendment provision. In this case, we had the 50% amendment provision, 19.1, but we also had 19.2. And 19.2 is commonly referred to in our industry as an anti-Dreamland provision. Because what 19.2 says is that every person who purchases covenants and agrees that any amendment pursuant to these declarations will be effective. We also, in this case, had 4.2, which not only specifically warns about use restrictions, but says that new use restrictions could be added. We also had 5.4 and 1.2.2. And it's also important to consider the Arizona Supreme Court's decision in Duffy, because in Duffy, all they had was a generic 50% amendment provision. And in that case, the Supreme Court allowed some owners to use that 50% amendment provision to exempt themselves out of restrictions completely and exempt themselves out of dues. That is much more significant to your neighbors than the re-imposition of the use restriction in this case. So any attempt to use Dreamland to overturn this case would in essence have to overturn the Supreme Court's decision in Duffy. Also, we've got the restatement that they attempt to rely on, but those illustrations that they cited fall into two categories. First of all, the restatement doesn't apply because we have Duffy. Also, this court's decision in Vales is crucial to this issue. This court, what happened in Vales is there was a generic amendment provision. The owners used that amendment provision to go from no leasing restrictions whatsoever to a complete ban on leasing restrictions. The plaintiff in that case argued the same thing Nicdon's arguing today, is that there's unanimous consent required. The trial court rejected that, and this court specifically said that aspect of the trial court's decision was correct. So in order to accept Nicdon's argument, this court would have to, in essence, overturn Duffy, overturn Vales, and ignore the Planned Community Act. Also, the restatement does them no good because the entire purpose of the restatement, it says specifically that its goal is to prevent, in the first comment, exactly what Nicdon is trying to do. Its goal is to prevent a small number of holdouts from blocking an amendment. And what the restatement does, 6.10, is it talks about, it says it only applies when the declaration doesn't contain a specific amendment provision. And that makes sense because how else could there be all of those cases I cited in my brief that specifically allowed rental restrictions if the restatement didn't allow it?
Counsel, so is it your opinion then that Desert Mountain could in fact, with the proper amount of votes, they could ban all rentals, all leasing of property in the...
With the appropriate amount of votes, yes. That is my provision.
And that's based on what?
It is based on the fact that, one, if the members voted on it, because that's what 1817 tells us. If the appropriate number of members voted, the members are the appropriate body to decide what type of restrictions they want in their particular community.
I'd like to ask you really quick about the motion for leave to amend the open meeting.
Yeah.
Let's assume for the sake of this question that we said they should have been allowed to amend to add the open meeting law. If there was an open meeting or a public meeting law violation, does that undo? Is the remedy for that avoiding of the entire?
Great question, but the answer is absolutely not. The open meeting allegations were unpled, unproven, and legally irrelevant for two reasons. The first is that none of those allegations pertain to the process at issue in this case. The process at issue in this case started on February 26th and ended on May 1st. All of the allegations are for board meetings before that process even started. And the only board meeting that was relevant for this particular process was the one on February 26th. And that one, there's no doubt that it was appropriately noticed because Nicdon actually was there. They attended and they testified that at the end of that meeting, they understood that this was going to the membership. So none of those allegations pertain to this actual process. And even if we were talking about analyzing individual board meetings, again, the legislature knows how to void meetings that are in violation of the Planned Community Act. They specifically did so in 33-1811, which is the conflict of interest statute. Contrast that to the open meeting statute, 1804, where there is no similar language. And in fact, I think it's C or D, Your Honor, states that any violation of the 1804, quote, does not affect the validity of any board action. And that makes sense because...
Thank you, Counsel. Your
Thank
time
you.
has run.
If Section 5.20 is ambiguous, there's a question of fact here. Mr. Ekmark cites to the testimony of Mr. Borsch. Before being deposed in this litigation, Mr. Borsch wrote a white paper where he gave the exact opposite opinion from what his testimony is. So that would result in this case going back for a determination as to the issues in this case. Secondly, Section 33-1817 did not abrogate Dreamland. What Mr. Ekmark is suggesting is that it's a restriction free for all. That based on 33-1817, you could impose restrictions on winter rentals, you could impose restrictions on investment properties, you could impose restrictions on, you can make a residency requirement. 33-1817 does not give an association the right to impose inherently unfair and unforeseeable restrictions against the consent of those people who are bound.
Let me go back to one thing. And the point was made that under 5.20 itself, there is a provision that says 10% of members. No adjustment, no modification. Clear, it has to be 10% of the membership. But in that same clause then, there is the language that I was asking you about earlier that ends with a who are present clause. Why would we not read those with just within the body of that provision by itself that one requires the entire membership and the other one, by its plain language, doesn't?
Because, and again, if you look at the context in which 5.20 was adopted, it was after the passage of 33-1812, which imposed a physical, which said basically, physically you have to be there, you can't vote by proxy. And the language there simply mimics that. It says how you vote. It's not a quorum requirement. It's not, that's a reading that's, at best, it results in an ambiguity. I'd like to address the stated reasons, because Mr. Ekmark, the safety security idea, it makes no sense. It makes this amendment irrational. We have the same people coming in. As long as they don't rent, they can occupy. So what we have here, the purpose of this restriction is to prevent some members from receiving remuneration.
What is the legal authority that allows us to inquire into the legitimacy of the justification? I mean, once the board has asserted that this is for safety and security, and that on its face is a reasonable justification, what is the authority for this court to look behind that to see if it's
Well, there's
legitimate?
several. First of all, it's section 3.5 of the restatement. It's inherent in the Kitchikoff case and the Esser case, where you can't impose unreasonable and arbitrary rules on owners. And you're not stuck with the stated justification. If you were, then we would have literally any rule that the board decides they want to adopt. We have to look at what the effect of this rule is. And the effect of this rule is to prevent Nicdon and other owners from receiving remuneration from the use of their property, but giving that same remuneration to the club's members. They have the right to rent. If you look at the amendment and the literature that went to it, can the club still engage in short-term rentals to prospects? Yes.
That's in the actual wording of the amendment that was
That's
voted
not in the
on?
actual wording.
Well, then-
That's
then-
in the literature.
Well, then how is that before us?
Well, it's before you based on the definition of who's an eligible renter and who's an ineligible renter. And if you look at the
Why do we
eligible,
go beyond the plain language of what the definition of who is an eligible renter?
because you have to look at the intent of this, you have to look at the effect of this, and the effect of having a definition of someone who's an eligible renter versus an ineligible renter. The only people who are ineligible renters are people that my client wants to rent to, but the club, who's both a member and also the club's members who are not members, they're free to rent to whoever they want under the application of the statute, and that is spelled out throughout the literature, and it's not in dispute.
Thank you.
Thank you, counsel. Thank you both for your arguments. Court will stand in recess to reset for the next argument.